Well, 90 slides. We'd like to call the hearing to order and ask folks to maybe get the anteroom doors so that we can start. We want to welcome you here to this legislative hearing, and I'd like to recognize myself for a 5-minute opening statement. In our first hearing this Congress, we heard about the great work states are doing when it comes to environmental regulations and how well equipped and qualified they are to take on that mission. Today we will focus directly on coal ash and legislation designed to give states a framework to build off their successes in the past handling waste streams under the Resource Conservation Recovery Act, commonly known as RCRA. Most people think of federal law when it comes to environmental protection, and we have passed many important environmental laws over the years. However, states also pass environmental laws. States have the same concerns about protecting the environment, and contrary to some of the things you might hear today, states establish and carry out a standard of protection through their environmental permitting programs. In fact, in our last hearing, we kind of highlighted that most of the inspections are done through the state agencies. For my example, the state IEPA, Illinois Environment Protection Agency, do a lot of the legwork, and it's obviously a partnership that's very important. That's actually what my notes say too. Regulators are directed to establish programs to restore, protect, and enhance the quality of the environment and to assure that adverse effects upon the environment are fully considered and borne by those who cause them, and that's in my home state of Illinois. While it may not use the same words Congress has used to direct EPA, the effect is exactly the same. The legislation we consider today sets out a new approach. It does not follow the same path as we have traveled with the RCRA before, which is for Congress to set a subjective standard that EPA must interpret and implement through regulations and enforcement. Instead, we are setting the standard in statute and charging the states with implementation. Just because it's different does not mean ineffective or not protective of human health and the environment. We heard the comments and concerns about the bill we passed in the last Congress, and we worked both across the aisle and across the Capitol to develop the text of this discussion draft. The legislation makes several key improvements. In particular, it establishes additional requirements for surface impoundments that aren't meeting a groundwater protection standard and requires impoundments that can't meet the standards within a certain time period to close. The discussion draft requires groundwater monitoring for all disposal units that are receiving coal ash and tightens the dust requirements. The bill also improves on the dam stability standards by requiring an annual inspection of the design, construction, and maintenance of the structures by an independent professional engineer. The long and short of it is Congress is perfectly capable of establishing a standard protection for coal ash. The states are perfectly capable and in the best position to implement robust permit programs for coal ash. And I have brought with me, as I have in different hearings, actually coal ash, as we've talked before, beneficial reuse, which is in concrete, which is in kind of a brick-like material. Obviously, we have drywall as part of the production. We have countertops. We have shingles. And part of this debate for us for a long time is ensuring that we properly define this waste. That's part of this debate, so that this stuff that has beneficial uses is not eventually labeled as toxic, and then we can't use it in the building of roads and bridges and schools and the like, which is what we've been doing now for many, many years. So that's part of the concern in which we bring this legislation forward, and we're excited at the opportunity to, as a former teacher in high school, the whole debate of how a bill becomes a law sometimes gets lost here because we push things through. We had a bill, as I said in the opening statement. There was concerns. The Senate started moving legislation. We've taken a lesson from both those processes. We're adjusting and amending those opportunities. There's some optimism, I think, that there's some common ground that can be found, and we look forward to moving this process forward, and this is just the first start of, I think, a couple different opportunities of negotiations in this process, and which I hope will end in a successful conclusion. So with that, I want to thank all our witnesses for being with us here today, and I'll recognize Ranking Member Tonko for 5 minutes for the purposes of an opening statement.
Thank you, Mr. Chair. Good morning, everyone, and I thank our Chair for holding this hearing on the discussion draft of the Coal Ash Recycling and Oversight Act. And thank you to our witnesses for participating in the hearing and offering your thoughts on this legislation today. We have dealt with coal ash as long as we have been burning coal, a very long time. Coal ash can be beneficially reused. Recycling of coal ash is a well-established practice, but not all coal ash can be safely recycled. And when it is improperly used or disposed of, coal ash creates significant problems. The Environmental Protection Agency, the EPA, was charged with studying coal combustion residuals back in 1980 when the Resource Reuse and Recovery Act, RCRA, became law. It has been over 30 years, and communities in many states have experienced problems from improper handling and disposal of coal ash. Spills from wet impoundments, windborne ash, and groundwater contamination have caused serious health and environmental problems and required expensive cleanup efforts. 5 years after the catastrophic spill in Tennessee, we're still without reasonable regulations to safeguard communities and ensure proper treatment of this waste. It is long past time to resolve these issues and indeed move forward. We need a policy that ensures safe disposal of coal ash, provides clear guidance to state agencies and the regulated industry, and an appropriate federal oversight role. Perhaps EPA can achieve that with regulation under the current law. If not, I believe we can develop a law that balances the concerns of all involved. The discussion draft does not meet these goals in its current form, so we have more work to do. I look forward to the testimony of our witnesses today and their thoughts on this issue. I'm willing to work with you, Mr. Chair, and our other colleagues to improve this legislation. Working together, I am convinced that we can move a bill forward that finally can provide a sound policy to deal with coal ash. And with that, I yield back.
Gentleman yields back his time. Chair now recognizes the Chairman of Full Committee, Mr. Upton, for 5 minutes.
Well, thank you. You know, our efforts to solve the coal ash certainly do continue with this hearing. We began the last Congress by asking, should we allow EPA to write rules that would bind every state regardless of geography, hydrology, history, economics, or should we allow the states to build and operate their own permitting systems? The answer that this committee reported, in which the House passed, both with bipartisan support, was a compromise. Gave the choice to the states to apply minimum federal standards specified in the legislation itself, or a state could vacate the field and let EPA step in and run the state's program directly. Mr. McKinley's bill, H.R. 2273, passed the House and with bipartisan support in October of 2011. Building on that House-passed bill, Senators Hoeven and Baucus in a bipartisan Senate group wrote S. 3512. It preserved the approach of our House bill but added more detail to the minimum federal standards. For example, it added a requirement that leaking surface impoundments meet a groundwater protection standard within a certain time period, or they are required to close. That bill also included a requirement that all structures that receive coal ash after enactment install groundwater monitoring within 1 year after a state certifies its program. The bill was introduced August 2nd of last year with Senator Hoeven and Baucus and 12 Republicans and 12 Democrats as original co-sponsors. And the text of today's discussion draft is actually the text of that bill, S. 3512. Now, we're eager to hear from our witnesses today as they focus on the details of the legislation before us. We welcome the suggestions to improve the text for sure. However, we do prefer to preserve the signature approach of the bill, minimum statutory standards implemented by the states. We welcome our first witness, Mr. Stanislaus, and thank him for sure for testimony that's quite useful as it directly addresses the legislation. That's what this legislative hearing is intended to do. We know that he would like to resolve this coal issue as well, and we appreciate that that goodwill. The dispute about how to regulate coal ash ties up the EPA in court and prevents all parties from moving forward. This legislation aims to settle that litigation. We also welcome our state environmental officials. We look forward to learning from them how they will develop certified programs that EPA can approve and whether the nuts and bolts of the bill are tight enough to make the vehicle work in the real world. I also expect the witnesses to answer questions about details of the legislation. Are the minimum federal standards the right ones? How do they compare with what the EPA proposed? Should we consider some type of timeline for state implementation? And do the states welcome the approach set out in the discussion draft? I appreciate the good work by Chairman Shimkus and yield the balance of my time to Mr. McKinley from West Virginia.
Thank you, Mr. Chairman, for the time that you've given me on this. Let me just kind of paraphrase again. Much of what you've heard so far on this is that the creation of fly, it's an unavoidable byproduct of burning coal. You get this product, this little dust. It's just an unavoidable byproduct. So I guess the fight here would be is if we don't want to have this product, then we don't burn coal. But that's not realistic. So what's happened over the years? We develop about 140 million tons of this fly ash annually. 40% of it's recycled, and 60% goes to landfills. But the 40% that's been recycled it's been blessed by the EPA as a non-hazardous material and should be used. As a matter of fact, under Bill Clinton, the 93 and the 2000 reports have both came out and supported. So the 40% issue should be moot. The real issue then is the disposal. How do you dispose of this product? And perhaps the argument that really comes down to it, do we want to have the federal government have primacy, or should the states have primacy? Now, the group, the recyclers, labor unions, utilities, co-operators, state environmental groups, all of the stakeholders in this think that the best way to do it is to have the state have primacy. But what I like about in this bill is that we actually begin with the federal standard. There's a minimum standard that's going to be set forth, and the states have to apply that. If they don't adhere to that, then the federal government does take primacy. So let's make sure we understand that if this bill doesn't pass, then what we're going to do is we're going to be back to, once again, what's been talked about for the last 30-some years, arguing over this, while we have fly ash that's created every day all across America is going to landfills that are not approved. Some states have no certified landfill requirements. Do we want to continue that or not? It's time this bill gets passed. And I'm particularly pleased from what I'm hearing from the other side and from the EPA is that this may very well be the year to do it, that we can find the compromise. And I appreciate very much the testimony that you're about to give and how we can work together to make this resolved, because this is not right for people to fear this is being disposed of in their backyard and there's no standards. It's time that we have standards and adhere to it, and we can do that. So this legislation is important, and I think it's going to resolve, I hope after 30-some years, we're finally going to resolve this problem. So with that, Mr. Chairman, I yield back my time.
Gentleman's time expired. Chair now recognizes the ranking member of the full committee, Mr. Waxman, for 5 minutes.
Thank you, Mr. Chairman. Today, the subcommittee examines a discussion draft that would govern the disposal of coal ash, the toxic-laden residual waste from burning coal. The language isn't new. It's almost identical to the bill reported by this committee in the last Congress without ever being examined in a legislative hearing. It is identical to the language that 90% of Democrats opposed when it was considered on the House floor in September of last year. It's the same language that has been exhaustively analyzed by the Congressional Research Service and found severely wanting. And it's the same language that has failed to get sufficient support in the United States Senate. Over the years, Congress and the states have developed a proven model for environmental protection that has successfully reduced pollution and enhanced the protection of the public health. We had a hearing on that model of environmental federalism just 2 months ago and heard from stakeholders that it continues to work well. States have received delegation for just over 96% of the environmental programs that can be delegated. This is an impressive track record that has protected the American people from pollution-induced respiratory diseases, from contaminants in their drinking water, from toxic environmental exposures that can cause cancers and other diseases. Despite these successes, the discussion draft we consider today would abandon the proven models of environmental protection and adopt an approach that we have every reason to believe would fail if enacted. This proposal will not ensure the safe disposal of coal ash. It will not prevent groundwater contamination from unlined ash ponds or prevent coal ash impoundments from failing catastrophically. It will not allow EPA to complete its rulemaking to identify the disposal criteria necessary to protect human health and the environment. I continue to oppose such an approach and believe that there is simply not the support for this proposal to become law. But as I've said for 2 years now, I'm willing to work with the majority on this issue to get a law if the chairman wants a law. That would require rethinking this legislation and listening to the expert views available to us. EPA, the Congressional Budget Office, the Congressional Research Service, all have relevant expertise on this legislation. Their views must not be dismissed, and in fact, relying on their expertise will only help us craft a much better piece of legislation. I believe this is an issue we should be able to resolve. We can provide certainty and reasonable standards that would work for industry, and at the same time, we can ensure that health and the environment are protected. But what we should avoid is remaining gridlocked on a stale proposal. That won't stop dangerous coal ash dumping. It won't prevent toxic contamination from leaking into the groundwater and surface water, and it won't promote beneficial reuse of coal ash. Whether it's by administrative or legislative action, it's time to resolve this issue and ensure the safe disposal of coal ash. Environmental groups and the biggest recycler of coal ash in the country have sued EPA to complete their regulatory process and get a rule finalized. Mr. Chairman, I hope we can work together on this issue, and if not, I hope EPA will move expeditiously to establish strong standards that ensure the safe disposal of coal ash. Yield back my time.
Gentleman yields back his time. Now we'd like to welcome our first witness, the Honorable Matthew Stanislaus, who's the Assistant Administrator for the Office of Solid Waste and Emergency Response with the U.S. EPA. Sir, welcome. Your full statement's in the record. You'll have 5 minutes. We have obviously a newer time system there with the green and the yellow and the red, and but we're going to be very generous. So, based upon the comments in the opening statements, we really look forward to hearing your opening statement because we are going to get input from the EPA here. And you're recognized.
Good morning, Mr. Chairman and members of the subcommittee. I am Matty Stanislaus, Assistant Administrator for the Office of Solid Waste and Emergency Response at the United States Environmental Protection Agency. Thank you for the opportunity to testify today on the committee's legislative discussion draft, the Coal Ash Recycling and Oversight Act. Coal combustion residuals, or CCRs, are one of the largest waste streams generated in the United States, with approximately 136 million tons generated in 2008. CCRs contain constituents such as arsenic, cadmium, and mercury, which can pose threats to public health and the environment if improperly managed. At the time EPA issued its proposed coal ash rule, EPA had documented evidence of damages to groundwater or surface water in 27 cases, 17 cases of damage to groundwater, and 10 cases of damage to surface water. In addition, EPA identified 40 cases of potential damage to groundwater or surface water. In the majority of cases, damages to groundwater and surface water were associated with the lack of standards necessary to protect human health and the environment, particularly the use of unlined impoundment units and the failure to monitor these impoundments and other associated units. EPA has also documented evidence of a number of damage cases due to catastrophic structural failure of coal ash impoundments, such as at the Martins Creek Power Plant in Pennsylvania, the TVA Kingston facility in Harriman, Tennessee, the sudden failure of surface impoundment retaining wall at the TVA Kingston facility in December 2008, and the resulting catastrophic spill of coal ash and their impacts to communities, rivers, and the environment highlight the issue of impoundment stability. Since EPA's proposed rule was issued, a number of additional reports have been submitted to EPA by several organizations that have identified dozens of additional damage cases. In addition, for states that have begun to require groundwater monitoring of surface impoundments, in almost all cases, groundwater contamination has been identified. Thus, it appears, based on all of EPA's information, improper management of coal ash in landfills and surface impoundments will continue to pose a threat to human health and the environment. Regarding beneficial use, coal ash can provide environmental benefits, and new applications may provide even greater benefits based on current studies. Some of the information confirms or strengthens EPA's views on the benefits of coal ash reuse. However, some information indicates that certain uses may raise concerns and merit additional attention. Some beneficial uses are in an encapsulated form, while others are in an unencapsulated form. EPA believes that the great bulk of beneficial uses, particularly in an encapsulated form such as concrete and wallboard, do not raise concerns and offer important environmental benefits. However, some questions have been raised regarding the lack of clear methodology to evaluate reuse of coal ash. Thus, EPA proposal sought additional information and requested specific comment on certain aspects of beneficial use of coal ash. To help resolve questions regarding the environmental consequences of beneficially using coal ash, EPA has developed a draft methodology which can be used to determine whether encapsulated products containing coal ash are comparable to analogous non-coal combustion residual products. We have also developed a draft application report for the use of coal fly ash in concrete and the use of FGD gypsum and wallboard as replacement materials. The draft application report is currently undergoing formal internal peer review. EPA is also developing a draft methodology for evaluating current unencapsulated beneficial uses of coal ash. We expect to issue both of them in the fall. Now turning to the committee's legislative discussion draft. Establish a framework for the management of coal ash, recognizing that documented damages associated with the mismanagement of coal ash support the need for action to address those risks. EPA believes that the proper management of coal ash requires nationally consistent standards necessary to protect human health and the environment. These standards should address the installation and use of liners for new units and lateral expansions of existing units, provide standards that control airborne dust and particulate matter, address the phase-out of unlined surface impoundments within a reasonable period of time, require groundwater monitoring for new and existing facilities, include location criteria, provide for corrective action where contamination or releases to the environment have been identified, including criteria for maintenance and structural stability of dams, address standards for closure and post-closure, and address the issues of financial assurance. The discussion draft addresses many of the areas I have just discussed. However, the discussion draft could be clarified in some important areas, including timelines for the development and implementation of state programs, criteria to help EPA determine when a state program is deficient, criteria for coal ash unit structural stability, deadlines for closure of unlined or leaking units, including inactive or abandoned units, and the universe of units subject to the permit program. Mr. Chairman, should Congress decide to address the regulation of coal ash through legislation, EPA stands ready to assist in that effort to help ensure that legislation establish a regulatory framework to regulate the management of coal ash in a nationally consistent manner that fully protects human health and the environment. Thank you, and this concludes my prepared remarks.
Thank you very much, and I think your opening statements and your submission is very helpful, and it's moving forward, and I appreciate that. So I'll recognize myself for the first 5 minutes opening questions. Mr. Stanislaus, doesn't the legislation in the discussion draft give EPA a continuing watchdog role to ensure that state permit programs meet the minimum federal requirements?
Thank you, Congressman. As I noted in my oral statements, there is a role for EPA to oversee the implementation of a state program. And in my oral statement, I noted that further clarity as to how EPA would execute that function is something that we could provide technical assistance regarding that.
Great, thank you. And you could, based upon the discussion draft, take over a state permit program if the state fails to correct identified deficiencies based upon the discussion draft. Is that correct?
Yeah, and thank you, Congressman. Again, referring back to my oral statement, there is a provision, as I understand the intent of that, for EPA to review and take over in certain circumstances. As noted in my oral statement, further clarity as to those circumstances for EPA to conduct that function would be beneficial.
Yeah, and I think the discussion draft basically identifies a base standard, and I think it's pretty clear, and I think you're alluding to that cautiously, that based upon that language as presented, if passed signed into law, if it's deficient in those base standards, you would have the authority. So let me go to, didn't the EPA state in the proposed rule that 40 CFR Part 258, the revised criteria for municipal solid waste landfills would be a framework for regulating coal ash?
In the proposed rule?
That the revised criteria that you all have already proposed, that using the municipal solid waste as a guideline would be a proper way of evaluating and moving CCR materials into obviously sites.
Congressman, I'm not familiar with that specific reference. Let me check that.
Well, and I would just obviously the preamble of the proposed rule basically says that, does it not?
Again, I don't have that in front of me, but I will check and put that into the record.
I think if you read the preamble, the answer will be yes, it does. And so our point is, this is not new. We're pretty close on how we need to get to where we need to get to, and we just want to continue to work with you and clean up some stuff. But the EPA is pretty much on the record on at least 4 provisions of this legislation, and the ability to have a guideline, the ability of the state, of you all to preempt if the states don't meet the guidelines, but the ability of the states to actually to operate this, and that's what the legislation is intended to doing. Consensus seems to be emerging in support of coal combustion residuals being dealt with under a non-hazardous regulatory framework. Do you agree?
Well, again, I mean, with respect to you asking regarding the legislation, I mean, so again, I think there are areas of further clarification regarding how the coal ash management should be executed.
Are you prepared to give us any in this legislative hearing any words and clarifications that might be acceptable, or are we prepared to do this after the hearing and in discussions with you all and committee staff? I mean, if we're not asking these questions and not going to glean from you what areas and language that would be helpful in perfecting the language, when do we have a chance to do that, especially in an open forum?
Sure. Well, again, we will provide specific details in our technical assistance role. And so there are areas, as I noted in my oral statement, that could be improved. And so I think it'd be helpful for me and my staff to work with your staff, providing details regarding potential areas of improvement.
Okay, let me, my time's running out. EPA cannot issue enforceable permits under Subtitle D, is that correct?
That's right.
And from an enforcement standpoint, isn't it better for facilities to operate under an enforceable permit instead of a self-implementing regulation or regulations that are only enforceable through citizen suits?
Well, as I understand the legislation, it does provide that the states would issue a permit and oversee that. And
isn't that preferable than fighting through the courts and having citizen suits across the country trying to delineate this, clearing this up, and putting a responsible party involved? And this, as we'll hear from the state regulators, they're willing, ready, and capable of doing. In fact, all states except for Florida and South Dakota are part of ECOS, even New York and California and Massachusetts, and they all agree with this approach.
Yeah, EPA, under the subtitle D, the construct is that the states, in fact, go forward and implement that, some through a permit program. Even under the other titles, EPA delegates that authority. So there are many circumstances the states do, in fact, we rely on the states to implement the solid waste programs. In many cases, that is done through a permit program and enforced by the states.
Perfect. Thank you. And now I'd like to yield to the ranking member, Mr. Tonko, for 5 minutes.
Thank you, Mr. Chair, and thank you, Assistant Administrator Stanislaus, for testifying today. EPA has proposed two alternative regulatory approaches to address the risks posed by unsafe disposal of coal ash. Both approaches include requirements to address failures of wet impoundments, dust from ash landfills, groundwater contamination, and other potential risks. The Subtitle D proposed rule includes detailed technical criteria developed by EPA to protect human health and the environment from the risks associated with CCR disposal. Getting these technical criteria right is critically important because they ensure that coal ash disposal sites are structurally sound and don't pollute the air or pollute the water. Proponents of the discussion draft that we're considering today have said that the draft contains many of the appropriate criteria, but I have concerns that significant safeguards are missing. In the last Congress, EPA provided this committee with technical assistance on whether legislation similar to the draft we are considering today included all of the elements necessary to protect human health and the environment. So I would like to ask a few questions to understand whether the new draft addresses those concerns. First, EPA's technical assistance states that under the language we considered in the last Congress, EPA would not be authorized to develop criteria tailored to the specific risks of coal ash disposal. Does the discussion draft we are considering today address that shortcoming?
So are you referring to the technical assistance for last year's House bill or the Senate bill?
The House bill.
Okay. My understanding, the draft discussion is based on the Senate bill. Is that not correct? Okay. So let me get back to you in terms, if you're asking a comparison of technical assistance on the Senate bill, I can get back to you regarding what we provided on the Senate bill. So I can provide that to you. But generally, as noted in my oral statement, there are areas that we are willing to work with you and the committee in terms of areas of further clarification in the areas that I've articulated.
Okay. And EPA's technical assistance states that the structural integrity requirements in the previous language were deficient because they did not address the full volume of liquid to be stored. Do the changes in this discussion draft address those deficiencies?
Yeah, speaking to the discussion draft, it does address liquids, and what we've said is that the further clarification as to the standard for which structural integrity would be judged against. The further clarification would be beneficial.
Mm-hmm. And EPA's technical assistance states that the previous language did not include the long-standing operating criteria for wet impoundments developed by the Mine Safety and Health Administration. Does this discussion draft apply those criteria?
My understanding that it does not, that there is a provision requiring a good engineering practices as the basis of structural integrity.
And EPA's technical assistance states that under the previous language, dry landfills would not be required to comply with many of the operating criteria that currently apply to municipal solid waste and would be applied to coal ash under EPA's proposed rule. Does this discussion draft fix that flaw with the previous proposal?
I am not sure about that.
Okay, is there a way you can get back?
Yeah, I can review that and get back to you.
Okay, that would be most appreciated. So I thank you for your response, Mr. Stanislaus. Let me just indicate this proposal eliminates EPA's rulemaking authority and replaces the agency's expertise with that of this panel. So it is essential that we get these disposal criteria correct. I hope that the committee will engage with you as we move forward to address these and other deficiencies in this legislation. I believe it's absolutely critical that as we assist those in the industries involved with the guidelines, with the certainty, and with the policy initiated here, that we can get things done to work in the best order possible. So with that, I see my time has almost expired, and I'll yield back. Thank you, Mr. Chair.
Gentleman yields back his time, Chair, and I recognize the gentleman from Texas, Mr. Barton, for 5 minutes.
I'm not going to use 5 minutes. I'm going to ask one question, then I'll yield to Mr. McKinley or Mr. Johnson or back to the chairman. I missed most of your verbal statement, but my question is pretty straightforward. Does the EPA have an official position on the discussion draft? And if they do, what is it?
We do not have an official position. In my oral statement, I've noted there are areas that the bill does, in fact, advance the basic requirements that we believe is necessary for safe coal ash disposal, and there are areas of further clarification that we're willing to work with the committee to expand upon.
Could you characterize the EPA's position as wishing to cooperate with the committee on this bill or wanting to be confrontational?
We are absolutely willing to cooperate.
All right. Thank you, sir. And I'll yield to whoever you want me to.
If I would claim your time.
Okay. I yield back to the chairman.
Thank you. And I would just like to follow up in that question. So EPA is not taking a position in opposition to the bill.
That's right.
Okay. And I think that's important. And then I'll just continue. Let me ask, on the legislation, doesn't the legislation require issuance of enforceable permits to all coal ash disposal facilities?
My understanding of the legislation is that the states would implement a program to issue permits. So the area of further clarification is clarification regarding timeline of that.
Yeah, and I think that's something we could. I mean, my understanding of your testimony is that there are 4 things you kind of like. There are 6 provisions that you think we need to look at. Mm-hmm. One of those being establishing a timeline.
Yeah.
So I think that's something I think we can be helpful and work on. But it's my understanding on the issue of the question that the way the language is drafted is that we do require enforcement. Now, you might question the standard of enforcement, not even standards, because we believe the states can enforce it. Mm-hmm. We may have a question about what are the standards, right?
Yeah. But
I don't think there's any dispute in the language that there would be, and I'm just making sure I say it properly, that there's an issuance requirement and enforceable permits in this draft language.
I believe the language or the intent of the language is to put in place a permit program and implement a permit program. And again, assuming we could address the timing question, there's also the what universe it would apply to. So people give me notes, but
me too. So as
so I think one of the areas is the definition of what's covered, I guess. So.
Okay. Let me ask, is a Subtitle C rule still on the table?
Well, again, as Congressman, we've noted in my testimony that we are evaluating a number of comments, about 450,000 comments and data, and also there's additional data which will inform the risk and the management, the preferred management mechanism to address that. So the additional data, which we would want the public to review before we make a decision, we want to get that out to the public, and then that will inform which is the best technique given all the considerations.
So for the public, moving on legislation could actually create a quicker standard of protection versus waiting for a process going through your due diligence. Could.
I won't comment.
All right. What is the agency, do you have a timing, any timing? I guess that's a follow-up to legislation could be quicker.
Well,
you have a timing, any timing?
I don't have a specific time frame in mind, and we've laid out in filings that we will have some idea in about 6 months in terms of based on the ability to get public input on this data. Right? We will. It's not that we will be able to act in 6 months, but in 6 months based on the data being submitted to the public for review and comment.
So I guess, again, we just follow up. We believe that legislation would help you all deal with the pending CCR deadline you're occurring through litigation. You're probably not going to answer that question, but I think that's a thing that we can debate and discuss. So with that, Mr. Barton's time's expired, which I was able to use, and I now yield to the Chairman Emeritus of the full committee, Mr. Dingell, for 5 minutes.
Mr. Chairman, I thank you for your courtesy. This is a very useful hearing. Reminds me, however, of a Greek tragedy. I see us sitting here like the chorus and anticipating that terrible calamities are about to come, and we don't know what to do about it. Well, there is a way out of this thicket, and I want to commend you for having the hearing because I think this just might be a beginning. Having said this, I've got a bunch of yes or no questions, and I hope that you'll respond referring to the witness. On other waste issues, states create their plans within a certain time frame and with certain federal requirements that they are obligated to meet. Is that right?
I'm sorry, could you repeat that question?
I'll dispense with that question. Do you believe this draft bill has the timelines and minimum legal standards of protection to ensure that proper program plans are implemented in the states? Yes or no?
Well, that is one of the areas that I've noted in my oral statement
Yes or
could be clarified.
Okay. Would you submit additional record information for the record?
Sure.
And I don't want to see you toe dancing around. Take a firm stance here because the situation stinks, and quite honestly, the legislation is not good. This bill would create regulatory requirements. Under a normal regulatory process, if these requirements, such as a legal standard for protection, needed to be updated or to better address the issue, there would be a comment period to obtain input from industry, stakeholders, and the public. Isn't that right?
Yeah, my understanding of the draft
yes or no?
My understanding of the draft legislation is that in implementing...
I have a limited time. Please say yes or no. There is no requirement in this bill that any future changes should go through a public comment process. Is that right?
Again, my understanding of the legislation is that in implementing the program by the state, it will be subject to public input and comment. However,
you are not being helpful, sir. Under EPA's proposed rule to establish requirements to address this issue, in your testimony, you said that EPA received nearly 500,000 public comments, solicited public data, started drafting a methodology to evaluate the beneficial uses. Under the legislative proposal before us, would EPA have the authority to gather public comments, technical data, or develop methodologies in the future to improve the implementation of the program proposed in the bill? Yes or no?
My understanding of the legislation is that the legislation would prescribe to the states to implement a program and a permit thereafter.
Submit additional information for the record. What 4 or 5 national standards you believe should be specifically addressed and added to this legislation to ensure that there is national conformity amongst the several states?
Yeah, as I noted in my...
Would you submit that for the record?
Sure, absolutely.
Now, do you believe this legislation as currently written would require these standards to be included in state program plans? Yes or no? Would you please submit that for the record?
Sure.
Mr. Chairman, from what I'm seeing today, it appears there's much we need to do to prevent spills like that experienced in Tennessee and more recently in Wisconsin when we had a tremendous gusher of nastiness flowing into Lake Michigan. Now, I'm just a poor Polish lawyer from Detroit, but I would remind members of the subcommittee that we are not engineers, and we must give EPA the flexibility to implement appropriate performance standards without having to come back to Congress for approval. Traditionally, Congress and this committee have given EPA authority to develop regulations and to address particular issues, but this bill jumps straight to the regulations without knowing whether the regulations are sound or not. And I am concerned that we may be setting, quite frankly, a most disturbing precedent, one which is inconsistent with the Administrative Procedures Act, and that allows regulations to be set without the extensive public comments and technical data that are needed from industry and from stakeholders. I hope my friends on the other side will recognize that we're imposing a congressional straitjacket on the EPA and the administrators of this program. The end result will be, if we're right, it might be fine. That is most unlikely. The probabilities are we're going to find we're wrong. We have no flexibility here that I can discern. EPA can't find any, and we're not getting much help from the witness, but it is urgently necessary that we consider these facts and that we do these things intelligently. The industry's got a legitimate complaint. We ought to hear it. We ought to do something about it. But we ought not jump blindly in and set a bunch of standards about which we know nothing and simply prolong the problem and increase the litigation that's going to curse us if we pass the bill as it now is. I look forward to working with you, and I hope you'll cooperate with me in trying to get a bill that makes some sense. Thank you.
I thank my colleague every time I hear from the poor Polish lawyer. I check my wallet. So with that, I'd like to recognize the author of last Congress's legislation and the member who's intimately involved in this, Mr. McKinley, for 5 minutes.
Thank you, Mr. Chairman, and again, thank you for appearing before the committee. You're right. This thing has been hanging for 30-some years. And we passed a bill 2 years ago. We passed a bill a year ago. We're back at it again. If we continue with this, with being stonewalled, I guess that argument of making perfect the enemy of good, and we do not pass a bill, can you help paint the picture of what happens? Won't we continue to be disposing of fly ash in the way they did it in the 40s and the 50s? Because there are some states that have no regulations whatsoever on this. So if we don't do something, aren't we really challenging people as a result?
I agree, Congressman. As I noted in my oral statement, there are ongoing damages that are occurring and past damages from particularly kind of the unlined impoundment kind of scenario and the particular requirements that I've articulated in my oral statement, things like lining, things like monitoring, or things that will be necessary to protect against those risks. So I think we do need some action.
What about the? Are you? I think I heard you make some remarks earlier in your opening statement that the 40% that we recycle, the beneficial recycling. You're still of an opinion that we should be able to continue to beneficially recycle about 40% of the product.
Yeah, I believe it's 37, but yeah, close to 40. Yeah.
So if this legislation doesn't go through, and I want to paint that probably the worst picture would be is that I believe, isn't there litigation now?
There is litigation now.
Okay, and that litigation wants you to call this a hazardous material?
My understanding of the litigation is for EPA to move forward on a timeline for regulating the disposal of coal ash. Yeah.
Under a hazardous waste landfill.
Let me get back to you. I don't believe it is prescriptive in that way.
I thought there was something to that effect that would label it, and I just know that if something were hazardous, then none of us should be using that. We shouldn't use it in drywall. We shouldn't use it in concrete if it's hazardous. Would you?
If it's hazardous, no.
No. And I think that's the EPA's already has determined that it's not a hazardous material. We just need to make sure that we dispose.
With fierce winds gusting at 20 miles an hour, this won't be easy.
I think I'll fight the boat! Pull him! Come on, man!
Me and my buddies spend most weekends down in a wealthy suburb that's overrun with white-tailed deer. We kind of stand out like sore thumbs here, but it's worth it. We get some of the best hunting here in the Northeast.
Hunting deer in the suburbs has a whole different set of challenges than hunting them in the wild. Isn't that heartwarming? A family, out on a stroll. Now get the hell out of here so I can shoot something.
Chasing Tail premieres tonight at 10 on History, made every day.
I got a log road that I need built.
Yeah, I've seen a road built in the book once. It's not that hard. Sure hope we can do this.
Cut her, Joe. Cut it.
Whoa, 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 Joe, stop, 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 stop! Whoa, whoa, whoa! Jesus!
The dramatic season of X-Men continues. Sunday at 9 on History. The moments we share today inspire the stories we tell tomorrow. The luxurious Infiniti JX, a 7-seat crossover that actually seats 7 comfortably. With innovative second-row seating that makes third-row access effortless, even with a child seat installed. So your family can share every moment together. Right now, lease an Infiniti JX for $489 a month. Infiniti, inspired performance.
At Passages Malibu, we treat and heal the underlying causes of addiction so you can live a healthy, addiction-free life. This is not a 12-step program. I should know. I was an addict for 10 years. Now I'm not.
To end your addiction now, visit PassagesMalibu.com or call 888-535-CURE.
Living near coal ash disposal sites. In technical assistance you provided to the committee last Congress, you identified multiple principal contaminants of concern in coal ash, including arsenic, cadmium, lead, mercury, and many others. These heavy metals pose very serious threats to human health. Would you, for our hearing today, please identify briefly some of the health effects of these contaminants?
Well, let me commit to get back to on the record in terms of all the contaminants we've identified and in the bill in terms of the specific health impacts.
Just generally the ones that I've mentioned, which came from the list you provided last time: arsenic, cadmium, lead, mercury. Can you just identify a few of those?
Well, without getting into the specifics of each of the contaminants,
right.
So generally you could have, depending on the contaminant and the contaminant level, you could have some developmental issues, sometimes of non-cancer and cancer. So it all depends on the particular contaminant you're talking about. So what I can do is, after the hearing, provide a breakdown of each of the contaminants and the various health impacts based on the level of exposure.
I would appreciate that for the record, but I think that's a postlude to the previous questioner's sense of urgency that we need to get something done, because these are very serious health threats, and we need to do it in a way that that is a good piece of legislation, because the lives of people in the area, surrounding areas, depend upon it. I'll just turn to a little bit a different way of asking a similar question. In your proposed rule for coal ash disposal, EPA identified 3 main pathways of exposure to these contaminants. 1, leaching from unlined units. 2nd, direct uncontrolled discharges in the case of a structural failure of an impoundment. And 3rd, fugitive dust emissions. So the question further to the record, would you discuss, please, some of the primary public health and environmental impacts that these 3 types of coal ash exposure can create?
Well, those are the exposure pathways. So those identify how a person would be exposed.
Right.
And so the various categories of health consequence would occur from that exposure, be it developmental, non-cancer, or cancer. So you can have different kinds of health impacts, but depending on whether it's inhalation,
right,
whether it's ingestion.
Right.
So I don't have that breakdown, but I can provide, depending on the pathway of exposure, the particular contaminant, and the kinds of health impacts. I can provide that for the record.
So am I right then in drawing the conclusion that there are multiple kinds of exposures with multiple serious health effects, because some of it's from the dust, some of it's from the discharge, some of it's from leaching? I mean, different ways that it can enter the environment, that a person's health can be directly affected by it. Would that be a fair assessment?
That's correct. If it's improperly managed, you can be exposed in multiple different ways. So if you don't have effective controls of dust, you could inhale it. If you don't have effective controls of leaching, you could get into the groundwater. And you could drink that. So there could be a multiple of different ways, depending on whether it's managed well or not.
Thank you. And finally, I want to follow up on the storage liners issue. My question is, will any kind of liner work to prevent leaching, or are there certain technical specifications that must be met?
Well, clearly it depends on the type of liner, and then also ensuring that the liner is within a management framework, meaning a monitoring program and oversight program.
So it's not just, and first of all, not any kind of liner will work. It's got to be some specified kind of liner. You don't have to go into the details here if you don't have that information, but there has been work to uncover and figure out what that kind of liner is. Am I correct?
There are industry standards in terms of the nature and particular materials for that liner.
Okay, so there has already been research done.
And implemented in certain parts of the country.
And implemented already, and studied to see if it's effective.
Yeah.
Okay. Well, the conclusion that I draw is that there are some robust specifications already, and I'm led to conclude that these are very serious concerns, and I hope that my colleagues will work with these technical experts at EPA, hope we all will, to ensure that we address each of these exposure pathways appropriately and sufficiently, and have that be part of the legislation that comes, so that the bill will have some teeth in it and it will be effective in finally addressing this particular challenge. And I'm looking across the aisle because this is going to take the efforts of all of us to make sure that these standards are met. And I yield back the balance of my time.
Generally, his time's expired, and I would just say that in this draft is really the Senate bill from last year, which was changed from ours. So it does have the groundwater, it does have the dust, it does have the levee issues and standards. It also Mr. Stanislaus mentioned previously that the technical considerations. This is part of the Senate bill, so some of the observations are based upon the old House bill, not this draft bill, which is the part of the Senate language. That's safe to say, I think. So I'd like to yield, and I apologize to the gentleman from Ohio. He should have went previous to the gentleman from West Virginia, but I'm just scared of the guy from West Virginia. So to recognize Mr. Latta for 5 minutes.
Well, thank you very much, Mr. Chairman. I appreciate it. And I greatly appreciate your testimony today and welcome you before the committee. And, having served in the Ohio General Assembly, I truly believe that the states really know their citizens' needs better than the federal government. And also the states also believe that we got to protect not only our citizens' health, but also the environment, while at the same time ensuring job creation and growth, not only in Ohio, but across the country. And Ohio currently requires permits for both coal ash landfills and surface impoundments, and have continuously worked to improve the requirements, including those for liners and groundwater monitoring. Additionally, the Ohio Department of Natural Resources has its own program to monitor and prevent impoundment failure. Because of the quality of the program, Ohio EPA considers the risk of catastrophic failure of Ohio coal ash surface impoundments to be low. As you can see, Ohio, like many other states, have quality coal ash management measures already in place. And I believe that the Coal Ash Recycling Oversight Act of 2013 will allow them to continue this ability. And if I could ask you this first question, given the measures that Ohio and other states have or are working on right now, and are currently putting into place, do you believe the states have that ability to ensure proper management and disposal of coal ash under the proposed legislation?
Oh, absolutely. I mean, there are many examples. I don't know, I can't tell you at this moment specifically about Ohio's program. There are many examples of states doing a really good job on coal ash management. There are also other situations where I think even the states would acknowledge that there are places where it's not been effectively managed. Even a state a survey among state waste managers have concluded that there are areas that is not managed well. But I can't talk specifically about Ohio's program.
Okay, well, thank you. And to ask a little, kind of a follow-up and ask some other questions that the gentle lady from California was mentioning a little bit earlier about liners. And if I could ask a couple of questions in regards where the EPA would like to discuss. Do you agree that the bill contains a provision for requiring liners?
Yeah, my understanding that the bill does require a provision for liner, and again, my oral statement is that there are there's one of them is where additional clarity as to how that will be implemented would be helpful.
Okay. And do you also agree that the bill contains a provision requiring groundwater monitoring?
Congressman, my understanding is that the bill would require groundwater monitoring.
Okay.
Yeah.
Do you agree that the bill has a deadline for the installation of the groundwater monitoring?
Congressman, my understanding that there is a deadline for installing groundwater monitoring.
Okay, thank you. Do you agree that the bill includes all of the constituents identified by the EPA as being of concern for coal ash?
I believe that's correct. Let me verify, but I believe that is correct. But let me verify and place a statement on the record.
Okay, thank you. Doesn't the bill set a timeline for meeting the groundwater protection standards for surface impoundments that are incorrective?
That is something I'm not sure is clear, but
Okay.
let me
Well,
check.
if you'd like to get back with us on that, that'd be great.
Yeah.
Do you agree that the bill requires control of fugitive dust?
It does have a provision for fugitive dust control, and again, it could be another area where further clarification of how it would be implemented could be beneficial.
Okay. Does the bill require financial assurance?
That is something I'm not sure.
Okay, if you just want to get back with us on that, we'd appreciate it. And doesn't the bill contain location restriction for coal ash management and disposal units?
I think that's another area where I think it could be further clarified. That's a bit ambiguous to us.
Okay. And then, with my remaining time, in your opinion, has the EPA developed a risk assessment that supports a determination that coal ash should be regulated under Subchapter C or Subtitle D, excuse me, Subtitle C or Subtitle D?
So, yeah, as noted earlier, that there is substantial additional data that's been provided to us by multiple stakeholders that will inform our risk assessment, and so we're not in a position, and we soon will be, hopefully, to make that judgment. So, based on that, it'll inform the best management regime to safely address the risks that we have identified.
Okay. Well, thank you very much, and Mr. Chairman, I'll yield back the balance of my time, and if the witness could provide us with those answers, I'd appreciate it.
Sure.
Gentleman yields back his time. The chair now recognizes the gentleman from California, Mr. McNerney, for 5 minutes.
Thank you, Mr. Chairman. I certainly wouldn't want to live downstream of a coal ash waste disposal site, but the conflict seems to be between federal authority and state authority, and the question I have is, some states are going to do a good job, some states may not do as good a job. If a site is leaking and poses a danger to the people in the groundwater, et cetera, does the EPA have sufficient authority in this bill to go in and take steps to remediate the situation?
Well, as I understand the program, it would require the states to set forth a permit program and then implement the permit program and oversee that. In terms of EPA's role, that's one of the areas that I noted earlier that could be further clarified as to under what circumstance it could play a role in the oversight.
So basically you're saying that it's not sufficiently clear in the proposal when the EPA should and can step in.
Yeah, it could be further clarified, and we're willing to provide technical assistance on potential areas of clarification and some analogies to other programs that we've had that role and where we work in partnership with the states to do that.
Is that something that the EPA is working with this committee to try and clarify the language?
We can, absolutely.
Mr. Chairman, is that something that you're looking forward to
If
doing?
the gentleman would yield, I would say that the discussion draft addresses ponds and that are unlined and leaking, and the bill requires unlined leaking impoundments to meet groundwater protection standards within a certain time period or close. Is that correct?
Yeah, so there are closure requirements, and again, it could be further clarified as to the timeline and what's the trigger for closure.
So, regaining my time, then, in an emergency situation, would the EPA have the authority to go in and take the steps that are necessary to remediate the danger?
Yeah, again, under the legislation, that's an area that could be further clarified in terms of EPA's role. I mean, clearly there are situations if there's imminent substantial endangerment under other of our authorities that we can and we have get involved to address those emergencies.
So the answer is yes, is what he's saying.
It didn't sound like a yes to me, Mr. Chairman.
I think it was.
Now, the EPA doesn't have the authority moving to the planning and design stage to impose design standards. Is that correct?
My understanding of the draft framework is that that'll be up to the states to determine the details regarding that through their permit program.
Do you use the word encapsulated several times in your oral testimony? Could you explain what that means?
Sure. It simply means in the beneficial use world, coal ash can be beneficially used in circumstances where essentially it's fixed, like in wallboard, like in concrete. And there are other areas where it's not fixed. In fill operations, as an example, agricultural use, as an example. So there are a variety of areas of its utilization. So in terms of developing methodology of addressing how it's safely used, we have to look at how it's used, and that's the methodology we're currently developing, with the first set of methodologies to be encapsulated, and we anticipate that to be issued in the fall.
Well, then encapsulated means commercially viable encapsulation. It doesn't mean encapsulated specifically for the purpose of disposing it safely.
Yeah, I use that terminology not relating to the disposal regime as it relates to just beneficial use.
Now, some toxic wastes are encapsulated, say, in a glass container that won't leak for many thousand years. Is that prohibitive in this case for coal ash because the volume is too big, or is there some way to encapsulate it so that it can be disposed of safely for generations?
Well, the framework for safe disposal is a combination of a lining system and a monitoring program, and we believe that can effectively address the risk that we've identified. Obviously, you have to look at also addressing fugitive dust with fugitive dust control systems as well.
So is that what you described, the lining, the groundwater monitoring, and so on? Was that the 2000 proposal with the EPA? Was that included in that 2000 proposal?
Yeah, those elements were included in that.
Okay. Thank you, Mr. Chairman.
Thank you, Chair. Now I recognize the gentleman from Ohio, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman. Mr. Stanislaus, thanks for being with us today. Does CERCLA give EPA's authority, the authority to address inactive or abandoned impoundments or units?
I mean, generally, CERCLA provides that if there is a threat from hazardous waste, its authorities can be used. You know, I'm not sure specifically where we use that in an impoundment scenario, but I can check and get back to you.
Inactive or abandoned?
Yeah.
Not active ones, but inactive or abandoned ones.
Yeah, let me check and determine whether we use that and whether we can use that.
If you could respond back in writing, that would be great.
Sure.
Also, Mr. Stanislaus, following Kingston, EPA inspected coal ash impoundments, some 600 of them, in fact, to make sure that they are structurally sound. You hired independent contractors who, in the agency's own words, are experts in the area of dam integrity. Do you agree with the findings of your staff that not a single coal ash impoundment was rated unsatisfactory and poses an immediate safety threat?
Yeah, I have to go back and look cumulatively at our postings, but we've done an assessment, and we didn't believe there was a scenario where there was a threat of imminent failure. And it's a combination of looking at how it was designed and inspection, and there were some recommendations to do some additional enhancements to prevent risk.
But none was rated unsatisfactory and none posed an immediate safety threat. Do you
Let me
agree?
check and put it on the record.
Okay, if you could check and get back to us on that also. Do you agree with the findings of your professional staff as well that the owners and operators of impoundments with identified deficiencies have responded responsibly by submitting response action plans?
Yeah, I will go verify that and place it on the record.
Okay, so you can get back to us with all of that.
Sure.
Mr. Chairman, with that, that's all my questions. I yield back.
Gentleman yields back his time. Chair now recognizes gentleman from Mississippi, Mr. Harper, for 5 minutes.
Thank you, Mr. Chairman, and thank you for being here. I know this is always fun, but we appreciate your time and,
Sure.
and expertise, and these are important issues, and we need to make sure we stay on top of this. You know, EPA has direct enforcement authority for municipal solid waste only when the agency determines that a state program is inadequate. The bill adopts essentially the same approach. Why is the approach not acceptable for coal ash?
Well, as I noted earlier, I mean, there are provisions for EPA to review a state program, the state's implementation program. Further clarity as to how it would conduct its review and under what circumstance it could engage the state's improvement of that or take it over. That's where there's some ambiguity.
Okay. You know, EPA has suggested that it would measure the adequacy of existing state programs based on whether groundwater monitoring was required. The bill requires groundwater monitoring, as you were asked and affirmed earlier, for all structures that receive coal ash. That is correct, isn't it?
Well, I think what the bill states that it requires groundwater monitoring for facilities that receive coal ash after the effective date of the legislation. So one of the areas of clarification as to what is the universe that will be subject to the groundwater requirements.
Okay. You know, EPA's proposed rules suggest the importance of having state coal ash permit programs address surface impoundments and require liners. The bill requires regulation of surface impoundments and liners for all new and expanded land disposal units, doesn't it?
I believe for those units that receive waste after the enactment date, okay. That's correct.
All right. Mr. Chairman, I'll yield back the balance of my time.
Chair thanks the gentleman, and then the chair recognizes the gentleman from Louisiana, Mr. Cassidy, for 5 minutes.
I yield back.
That's the quickest 5 minutes I've ever had as chairman, and chair thanks you. Seeing no other members, Mr. Stanislaus, thank you for your testimony. We're going to try to get you to yes a little bit clearer. I think we've made great progress since the last Congress, and we look forward to working with you, and we thank you for your time. And I'd like to ask the second panel to join us.
Thank you, Mr. Chairman. Thank you, members. Thank you.
We'd like to get started as promptly as possible, so we'd like to thank the second panel for joining us. Many of you have been here before and seen the process. I'll recognize you in order from left to right. I'll do it. You'll be given 5 minutes for an opening statement. Your full record statement has been submitted for the record, and we will begin. So the first, I'd like to recognize Mr. Robert Martineau, Jr., Commissioner from the Tennessee Department of Environment and Conservation. Sir, you're recognized for 5 minutes, and welcome.
Thank you, Mr. Chairman, and thank you to the committee for the invitation to be here today to discuss the issues about coal ash combustion and the legislation. I'm here today representing the Environmental Council of State, or ECOS, whose members are the leaders of state and territorial environmental protection agencies and my own state of Tennessee. Currently, I serve as on the Executive Council of ECOS as Secretary-Treasurer. The incident that has occurred in Kingston, Tennessee in 2008 obviously made coal ash management an issue of national attention. I'm here today to talk about the position of the states have on collectively on how to best move forward with regulation of coal ash. ECOS adopted a formal resolution on this issue, first passed in 2008 and reaffirmed last month at our spring meeting. I have attached that to my written testimony and asked that it be made part of the record. In short, our ECOS resolution agrees with the multiple studies that EPA has conducted over many years in 3 different administrations that coal ash is not a hazardous waste and should not be regulated as such. ECOS also agrees with EPA's 2005 finding that the states should continue to be the principal regulatory authority for regulation of coal ash. We recognize that there are some significant beneficial reuses for coal ash, and we support those. While some may suggest otherwise, regulation of coal ash as a hazardous waste would have an extreme chilling effect on the beneficial reuse of coal ash in concrete, roadbed material, and other uses. While we believe the states are the appropriate regulatory authority for coal ash, we also recognize there is some benefit for a national consistency approach. Therefore, ECOS has supported the bipartisan efforts of the House and Senate in the last Congress to create a federal program that allows states to regulate coal ash management and disposal under a set of federal standards created directly by Congress and implemented by the states. This is a new and thoughtful approach in regulation. ECOS sees this approach in this bill as a new path forward for federal involvement in some of the environmental challenges we face. We live in an era of constrained resources and government at both the federal, state, and local level. Challenges like coal ash would benefit from a new partnership model between the state and the federal government. The discussion bill today sets standards that protect human health and the environment and provides the states the opportunity to implement, enforce, and supplement the standards that are most applicable for each state. If a state chooses not to implement the CCR program, then EPA can and will. The states can ask for technical assistance from EPA and should they need it. And EPA is required periodically to assess and evaluate the state's implementation of those programs. If necessary, EPA can assume control of any state program if the state is unsuccessful in implementing those standards. Because the bill does not require EPA to promulgate the rules but creates the standards directly in the legislation, there are fewer delays in the program startup and there's an additional savings to the federal government. Obviously, any new proposed partnership and management of coal ash is subject to constructive criticism. I'd like to briefly address a couple of the criticisms identified in the Congressional Research Service report. First, the report noted that last year's bill lacked a timetable for implementation and other deadlines. While there are a number of timetables for closure and groundwater monitoring upgrades in the statute, there are a reasonable, well-defined schedule for the states to actually adopt the rules as necessary and develop the permit programs. It would certainly be reasonable. States are used to dealing with that as they implement other federal programs. This timetable would allow states to pass state rules, set up their regulatory programs, or supplement the ones they already have to get the permit program up and running to the extent they don't have one. Second, the CRS report also implied that a lack of direct EPA enforcement authority would make it less likely for the states to implement a program. I think that's simply contradicted by the record. ECOS has gone on record saying that they desire to run the state, regulate state coal ash at the state level. It's certainly not the case for Tennessee, and I don't think it would be the state case for any other states. A third criticism in the standards is that you can only set these kind of standards through the promulgation of rules. We believe Congress can create the basic standards for coal residual management, and the references to some of the existing regulatory requirements under Part 258 are already set forth in the standard and would be encompassed in setting forth the basic criteria that states would have to implement. Obviously, states can choose to do more if they need to do so to address particular geographic or other conditions in the state. Lastly, there is skepticism that EPA will be able to judge the state's performance on coal ash programs that would be created by this bill. EPA has been judging state air, water, and waste programs for 40 years through the delegation of programs. ECOS continues and the state agencies continue to interact with EPA every single day on the adequacy of their programs, and I don't think this program would be any different. The key is not to judge whether a state would implement the program exactly as EPA would, but whether the state has created an effective program for regulation consistent with the statute. A state must certify in detail to EPA that it has the equivalent statutory and regulatory authority to operate its CCR management and disposal program, including permitting, inspections, monitoring, review of site data, and enforcement. If the state falters, EPA can warn it. If the state fails, then EPA can take the program. This is the same authority that EPA has with all other delegated state programs. I'll close with a quotation from the March CRS report that I think is accurate and appropriate here. That a coal ash regulatory program would be created using a new approach does not mean that it cannot achieve its intended purpose. The bills would establish a framework that could be used to create programs to regulate CCR disposal, allow states flexibility to develop and implement the CCR management and disposal program, and specify some level of EPA oversight after states are implementing the program. We concur with that view that this is a new approach and that we think will work well to serve the public. Thank you.
Gentleman yields back his time. I want to thank you for your testimony. Now I'd like to recognize Mr. Stephen A. Cobb, professional engineer, Chief Government Hazardous and Waste Branch Land Division of the Alabama Department of Environmental Management. Sir, welcome, and you have 5 minutes.
Thank you, Mr. Chairman. Chairman Shimkus, Ranking Member Tonko, Honorable Subcommittee members, my name is Stephen Cobb, and I represent the Alabama Department of Environmental Management, or ADEM, which is the environmental regulatory agency in the state of Alabama. Thank you for the opportunity to address the subcommittee this morning. My remarks are based on ADEM's more than 30 years of implementing programs for the management of solid and hazardous waste in the state, including my personal experience in this area over the last 25 years. I've also submitted a more detailed statement for the committee's consideration. Alabama is home to one of the largest hazardous waste disposal facilities in the nation, and we have extensive experience managing higher risk waste. We clearly understand that a massive influx of lower risk solid waste, such as coal combustion residuals, into the hazardous waste classification would pose a threat to the level of attention needed for the safe management of all materials classified as hazardous waste, and also understand the challenges and resources required to permit and inspect such facilities. Alabama is also home to 29 medium to large municipal solid waste, or MSW landfills, so we also have a very good understanding of the protections that are provided by the MSW landfill standards under 40 CFR Part 258 to ensure safe waste management, to prevent future releases, and to require corrective action to address past releases where needed. As a result of having both types of facilities, we have a unique perspective on the issues which should be taken into account in considering how best to regulate materials such as CCRs. EPA has attempted to resolve the regulatory status of CCRs since the early 80s, but its difficulty in doing so may be attributed to two facts. First, CCRs generally do not meet the established criteria for classification as hazardous waste under Subtitle C, and second, there is no provision under Subtitle D for a national permitting program for these materials as non-hazardous solid waste. The enactment of new Section 4011, as described in the discussion draft, will solve this problem by requiring that CCR structures be designed and permitted pursuant to national standards under Subtitle D, the same standards used for MSW facilities. We must be aware of the tiered method by which waste has been regulated and controlled in this country for the last 5 decades, which imposes restrictions commensurate with the risk of permanent harm to human health and the environment posed by mismanagement. Looking at this system from the highest risk materials down, we see nuclear radiological waste at the top, followed by hazardous waste, municipal solid waste, industrial waste, construction demolition, and other waste such as yard trimmings at the bottom. Of these categories, only municipal hazardous, and nuclear radiological waste are currently subject to federally mandated permitting and management requirements, with the remainder addressed effectively through the jurisdiction and authority of the individual states. To include CCRs in the hazardous waste category would pose a risk of neglecting the wastes that are currently classified as hazardous due to the massive expansion of waste quantities caused by including CCRs in the category. For example, about 120,000 tons of hazardous waste are land disposed in Alabama each year, compared to approximately 4 million tons of CCRs that are generated within our state annually. Congress can look to the fact that Alabama and other states have routinely adopted and implemented those programs that are required and authorized by federal law as clear evidence that we will appropriately implement the national CCR program. In fact, in anticipation of first ever national standards for these materials, our legislature in 2011 authorized our agency to develop and adopt rules as necessary to implement a state regulatory program consistent with the federal requirements. As a safeguard, there is a role for EPA to evaluate our implementation of the permitting program and to demand changes if the state program is not meeting the national requirements, as well as for EPA to take over implementation of the permitting program if the state does not do so. In conclusion, Mr. Chairman, ADEM stands ready to implement a comprehensive permitting program for CCRs in Alabama based on national standards so as to ensure that these materials are properly managed now and into the future. But we must do so in a manner that provides the needed protections, can be implemented quickly and efficiently by the states, does not disrupt the established tiered system of waste management in this country, and does not result in needless duplication and proliferation of regulations and regulatory programs. Thank you again for the opportunity to address the committee this morning. I'll be glad to answer any questions you might have.
And thank you, Mr. Cobb. And I'd like to recognize Ms. Susan Parker Bodine, who's a partner with the law firm of Barnes and Thornburg. You're recognized for 5 minutes. Your full statement's in the record.
Thank you. Chairman Chimkis.
And I think there should be a button underneath that. There you go.
I think I remember that. Chairman Chimkis, Ranking Member Tonko, members of the subcommittee, thank you for inviting me here today to testify on the Coal Ash Recycling and Oversight Act of 2013. As the chairman said, I am a partner in the firm Barnes and Thornburg. I'm here to testify based on my understanding of RCRA, Resource Conservation Recovery Act, and its implementation. And that is from my past experience as being the Assistant Administrator for the Office of Solid Waste and Emergency Response from January 2006 to January 2009. But so I can give, I can understand the situation that the agency's in, but I also understand the prerogatives of Congress and certainly the role of Congress in developing regulatory programs, because before I was at EPA, I was working in this building for 11 years over on the Transportation Infrastructure Committee staff. So I can bring both perspectives to bear here. But first I want to talk about EPA and development of regulations. As I think some have already noted, EPA has been looking at coal ash management issues and any risks that might be associated with that for, let's just say 30 years, a long time. And in that time period, EPA has not developed a record that supports federal regulation of coal ash. And go into it, that's not the agency's fault, but they simply have not developed the risk assessment and the record to support it. They've acknowledged that back in 1998. This was a risk assessment that was done before the report to Congress in 1999 and the 2000 regulatory determination. EPA said that, this is a quote, EPA found that modeling uncertainty and error may have led to substantial overestimation of risks. That was in the 98 risk assessment. Again, EPA didn't stop work on this issue, but and continued to work on the risk assessment, continued to make changes to it, sent it out to for peer review in 2008. Again, the agency still did not fix the problems that had been identified, and the peer reviewers pointed out many of the same problems, and EPA acknowledged those issues, and there's a 2009 response to the peer review that's in the docket for the rulemaking that's pending, and that 2009 response says, and this is, quote, EPA acknowledges that the leaching profile described by Dr. Basta may be more realistic. However, the agency does not have the data to use time-varying leachate concentrations. And what that means is that EPA assumed that that there is no attenuation of any hazardous constituents if anything leaches out of a landfill. 100% of the constituents they assume would leak out at 100% level. Same issue from, again, quote from the peer review, EPA acknowledges there may be insoluble or otherwise unleachable contaminant mass that remains in a waste management unit. However, EPA has no data available, again, to support a different approach. They're assuming 100% moves out of a landfill or a surface impoundment because they have no data to assume otherwise. The agency is now, they're saying that they still want to fix the risk assessment. We do have a proposal out there, but the agency is saying they do still want to fix it. They're now pointing to data that was collected by the Office of Water when they were looking at revising Clean Water Act regulations, and in filings before the district court for the District of Columbia, the agency has said that this new data may change the assessment of risk by an order of magnitude. You heard Administrator Stanislaus say just a few minutes ago that they're not in a position to make a judgment on risk. And yes, that's right. They haven't. The risk assessment hasn't changed and has the assumptions that are very conservative. The bill takes an approach that takes EPA out of this box. They're in a box. They don't have a record to support regulation. By prescribing the standards in the legislation directly, they don't have to justify a rule. They don't have to justify standards based on risk. I heard Administrator Stanislaus say to you that they would like to provide technical assistance for criteria tailored to specific risks. Again, they don't have a risk assessment that can do that kind of tailoring, but the bill allows them to then go ahead and implement a program without creating those justifications. And as I think you pointed out, Mr. Chairman, the provisions of the legislation are based on provisions that the agency has already said are protective. You were asking Mr. Stanislaus to quote from his Federal Register preamble, and it does say that the Part 258 criteria present a reasonable balance between ensuring protection of the human health and the environment and the practical realities of facilities' ability to implement the criteria. So they've endorsed that, and you've also picked up the structural integrity issues and the fugitive dust issues. So what my message to you is that, actually my message to the agency is they should embrace this because it gets them out of a regulatory box and allows you to move forward, which we've heard from other members saying, let's move forward and address these issues, and let's do it. Thank you.
Thank you very much. Your time's expired. Now I'd like to recognize Ms. Lisa Evans, Senior Administrative Counsel from Earth Justice. Thank you, and your full record statements in the record. You're recognized for 5 minutes.
Thank you very much. Chairman Shimkus and members of the committee, I thank you for having me here to testify on this very important and very controversial draft discussion bill from Representative McKinley. I am Lisa Evans, Senior Administrative Counsel for Earth Justice, a national nonprofit public interest law firm dedicated to defending the right of all people to a healthy environment. On behalf of many public interest groups, thank you for holding the first legislative hearing on this complex bill. I am hopeful that this hearing will clarify the discussion draft's contents, including the very significant criticisms and questions by 2 recent CRS reports. I am also hopeful that we can find common ground on this critical public health issue, as well as common ground on the objectives of any coal ash legislation. Without a doubt, when mismanaged, coal ash harms Americans nationwide by poisoning water and air, and by threatening the very existence of communities living near high-hazard dams. We must work together to establish regulations that foremost prevent injury to health and ensure the safety of all communities, but which also allow safe reuse of coal ash that improves our economy, environment, and again, our health. I trust that all in this room share this goal. In that spirit, I offer these comments. While the bill at issue raises many important questions, the following four are among the most critical to understanding the problems with the bill. First, does the bill establish a national protective standard and federal minimum requirements? In other words, will the bill require every state to implement coal ash programs that protect the health of all the residents? The CRS report twice says no. The bill cannot guarantee consistent national protection, and we agree. CRS points to the absence of a national protective standard, which is unique among federal environmental laws. This approach is not just new and unprecedented, it is inadequate. According to CRS, the failure of the bill to require the protection of human health and the environment and to define key terms renders it impossible for the bill to guarantee that all states will implement consistent and health protective programs. Why is this so important? Currently, our nation is a patchwork of wildly different state programs, as Representative McKinley has pointed out. Tennessee and Alabama, for example, lack many basic and needed safeguards for the management of coal ash dams. To ensure full protection for the citizens of those states where there is considerable disproportionate impact on communities of color and low-income communities, the bill must contain a national protective standard and minimum federal requirements. We agree with CRS that this bill has neither. Secondly, does the bill provide EPA with backstop authority? In other words, does the bill provide EPA with clear and effective oversight to ensure that all state programs protect Americans from mismanaged coal ash? Again, the CRS reports twice say no, and we agree. According to CRS, the bill contains no backstop authority, as that term is commonly understood. Pursuant to this bill, backstop authority can only be exercised when states fail to implement the so-called minimum requirements. But as CRS pointed out in 2 reports, the bill's requirements are so vague that there are, in fact, no minimum federal standards. In other words, backstop authority is meaningless without a clear set of standards and deadlines that EPA can use to determine whether a state program is deficient. The CRS reports clearly say that the bill doesn't provide that criteria. Further, this bill deliberately and effectively removes most of EPA's authority over coal ash. EPA cannot take immediate enforcement action if a state fails to act. EPA cannot evaluate the adequacy of state programs before their implementation, and EPA cannot promulgate regulations where they are needed to protect health and the environment to reflect the increasing toxicity and changing nature of ash. Third, will the bill protect the nation's drinking water? No, it will not. The bill's failure to phase out unlined ponds, its failure to set a deadline for the permitting of dumps, its failure to require closure of polluting sites by a date certain, and its failure to ensure that all dangerous dumps are monitored will leave our water at risk of continued poisoning by arsenic, hexavalent chromium, lead, mercury, and more. Fourth and finally, will the bill prevent another catastrophic disaster? No, and yet I think all would agree that any bill must ensure that the earthen dams holding back millions of tons of toxic waste be made safe for all the communities unfortunate enough to live beneath them. I speak for many in the public interest community when I say that we too want an immediate end to the delay of the EPA's rulemaking, but any rule or any bill foremost must protect public health and safety. Together we can and must end the long-standing and serious threat to thousands of communities living near unsafe, unstable, and leaking coal ash dumps. Because every person in this room, every family in your districts, every citizen in this country deserves water free from ash contamination, air free of dust, and a safe and secure community. I appreciate the opportunity to comment, and I look forward to questions. Thank you.
And thank you. And the last testimony we'll receive is from Mr. Spadero, who is a mine safety and health environmental consultant. Mr. Spadero, I understand you're going to show some slides in your testimony. Is that correct?
Yes, I am.
We would just on the record, as we have submissions, at a certain amount of time, when you have slides, if we could see those in the same timely manner on the submission, that just makes it easier for us too. So that's actually part of your testimony. We should have received that 48 hours in advance too, but we're happy to, with asking for unanimous consent, to allow you to have the slides shown. So with that, I recognize you for 5 minutes.
Thank you. And I'll try to show these as I go, so we'll save time. I just want to thank you for inviting me here today and for allowing me to make these comments. I have been involved in the regulation of dams related to coal mine waste since 1972, when I went down to southern West Virginia as a young engineer to investigate the Buffalo Creek Dam failure, where 125 people died and about 4,000 people ended up having their homes destroyed by the failure of a dam that had not been engineered properly. And then after that time, I've worked for really the past 40 years in regulating both the environmental effects of mining and the mine health and safety regulations at both the federal and state levels. The management and disposal of coal ash is an issue with serious health and safety implications that warrant federal action to protect the communities living with this waste, particularly to ensure the structural integrity of more than 1,000 coal ash dams across the country. In the draft, in the draft discussion, there's just a mere mention, really, of the standards necessary to address these threats. The language is something vague, like good engineering practices. Well, and I'm going to show here in a minute the after effects of the dam failure at Buffalo Creek and several others. So when I went to Buffalo Creek and spent almost a year there, I went in about a week after the dam failed. And then I worked with a committee that was appointed by the governor of West Virginia. And their very first conclusion read this way: the lack of definitive, clear-cut, and enforceable laws with regard to the safety of mine refuse banks and impounding structures, both at the federal and state levels, was a major shortcoming that contributed to the disaster. Now I want to show, if we can, the first photographs of the Buffalo Creek dam failure. This is how destructive one dam failure can be. In this failure, the structure was about 60 feet high, contained 125 million gallons of coal slurry, and it failed in a matter of 15 minutes because there were no engineering standards in place. So after that, I was honored to work with we can go on to the next slides. I was honored to work both at the state and federal level in writing regulations that could govern these structures. And so we, over time, developed under the Code of Federal Regulations, under the Surface Mining Act, under 30 CFR 816.49, 816.81, 816.83, and 816.84 standards that have been in place since 1977. And then that was for the Federal Office of Surface Mining, and states then implemented those regulations. We also have, since 1977, federal standards that are enforced by the Mine Safety and Health Administration, and that's under 30 CFR 77.14, 2.14 through 77.216. Unlike the discussion draft, the OSM and MSHA regulations require specific, recognized engineering standards to be applied to the planning, construction, and maintenance of coal refuse dams and do not merely leave the design and maintenance criteria to an independent contractor. The failure that you see now on the screen was the Martin County dam failure that occurred in October 2000. That was a failure where a dam had been repeatedly certified by an engineer who was a contract engineer for the company who owned the dam. And then there's a similar failure that occurred this as recently as past December 2012. The engineer who had repeatedly certified that dam as safe was standing on top of the dam when it failed. So the EPA studies have shown that there are, the structures study, there are at least 25% of them were in poor conditions. They did recommend urgent action to stabilize those dams. 54 of the significant hazard dams were rated poor, and less than half of all the dams received a satisfactory rating. I want to say to you, I have seen, as you've seen here, the result of inadequate and irresponsible regulation of coal refuse dams, and these catastrophes that I hope never to see again, and I shall never forget the bodies of the people that I saw wrapped in the coal slurry in the weeks following the Buffalo Creek Dam failure, and hearing the voices of the survivors who had lost their families forever. Thank you.
Thank you, sir, for your testimony. I'm going to ask unanimous consent that Mr. Hall be recognized for the first 5 minutes.
Thank you, Mr. Chairman.
Without objection, the gentleman is recognized.
Thank you very much, and it's very important to Texas. I thank you for it. You make your usual request that we can submit letters in the future.
I have not made that statement yet, but with unanimous consent, we'll keep the record open for 5 days to receive questions and responses as per 10 days. 10 days. Without objection, so ordered.
No, thank you. I yield back.
Shoot, I could have done that, Ralph. Now, I'd like to recognize Mr. Tonko for 5 minutes.
Thank you, Mr. Chair, and let me thank the witnesses for their testimony. The proposal before us would establish an unprecedented regulatory structure wherein the specific technical requirements for coal ash disposal would be set in statute. I have serious concerns about that approach, not the least of which is the burden it puts on this committee to determine the appropriate technical specs for safe disposal. In order to better inform the subcommittee, I would now like to ask some of the same questions of this panel. Mr. Spadaro, you are an engineer with very compelling evidence that you offered with the photos that you've displayed. In your experience in determining what criteria are necessary to assure the structural integrity of waste impoundments is telling. I'm concerned that this proposal will not require impoundments to be designed for the full volume of liquid they will hold, and will not require the operating criteria currently applied to coal waste impoundments. So are those concerns justified?
Yes, sir.
And do you agree that the proposal before us is deficient on structural integrity?
Yes, it's remarkably deficient. I can't believe that 40 years after the Buffalo Creek Dam, I'm reading legislation that basically forgoes standard geotechnical engineering practice that's been applied to dam construction for the past really 50 years. And so that this bill is deficient in applying those standards.
Now, you've shared some very telling photos, but can you give a few brief examples of those deficiencies?
Yes. Well, as I said, both the Surface Mining Control and Reclamation Act and the Mine Safety and Health Act of 1977 were very specific in stating that standards should be established in the federal regulations through the regulation process. So as I said, I worked on the team of engineers and hydrologists who put together those regulations. We had input from the Corps of Engineers, the Soil Conservation Service, the engineers from within the specific agencies, and those people had the knowledge to determine what needed to be put into the regulations. And one of the main things is the requirements for foundation investigation, engineering analysis of the foundation areas of dams, engineering analysis of the seepage patterns that the dams might create, and the geologic conditions in the areas where the dams are being constructed. Also, standards for compaction of the material, and daily inspection standards under the MSHA standards, and quarterly inspections by federal inspectors, as well as the certification by the corporate engineer. So you have a checks and balance system where not just one person is saying the dam is safe. And that has worked by and large very successfully. There are 650 coal refuse dams in the United States. We know of several failures, but I can assure you without these standards, there would have been many more.
Well, I think this is something that could be addressed by delegating rulemaking authority to EPA to establish criteria that would meet a standard of protection. And rather than rescuing EPA as an agency, as has been suggested, it seems as though the concern should be with individuals, families, and communities that could be severely impacted. Mr. Spadaro, if we had to lay it out in statutory terms, what are the minimum requirements in your view that should be included here to prevent another spill like that which happened in Kingston?
I do recommend that the regulations be developed by EPA, and not just EPA, but a team of agencies with the expertise, as well as with input from industry. So I think the minimum standard would be that the dams be built using initially and requiring initially an evaluation of the stability of the foundation, the stability of the dam as it's being constructed, instrumentation of the dam with piezometers and slope inclinometers that can detect movement, minimum standards for compaction of the material, and minimum hydrologic standards, for instance, establishing design storms. We found in West Virginia we had to design many of the dams for the probable hydrologic consequences, the probable maximum storm, because there were large populated areas downstream. So you have to account for very large storms as well as the structural integrity of the dams. Those things, at a minimum, should be included in any proposed regulations or legislation.
Thank you, Mr. Spadaro. Thank you, Mr. Chair. I yield back.
Gentleman yields back his time. Mr. Spadaro, not a question but a comment. I was 12 in 1972, and I would hope engineering qualifications and standards have improved so much in the multiple decades, and that's why we trust the states to be able to figure that out. The other issue was this: you're talking about a coal waste dam. We're talking about coal ash impoundments. They're two different issues, and I just want to put that on the record. And I want to start with Mr. Martineau. Tell me, ECOS is who?
ECOS is the Environmental Council of State. We are essentially an organization of all my counterpart agencies. I'm the commissioner of the Department of Environment and Conservation for Tennessee. The titles vary slightly, but we have 48 of the 50 states are members.
And the two aren't, was I correct, Florida and South Dakota?
And South Dakota and
so New York and Massachusetts and
are all members.
California.
Yes.
And they all went on record with this resolution twice. Is that correct?
Yes.
Without objection.
I believe it was unanimous. Yeah, it was unanimous.
Unanimous. California, Massachusetts, which I think is telling. And I think that's the importance of your organization, and I just want to make sure we had that on record. The other thing, it was important, part of this whole debate came about because of this, beneficial reuse. And in the state of California, there were ads about concrete use that had fly ash, and they were targeting that reuse and the whole reclassification. And so for my colleagues, some of them are new on the subcommittee, the importance is if we then turn this all into a toxic waste dump, you've got, and Mr. Cobb, I think your testimony talks about where do we put it and how do you manage it? So I just want to tie that into this debate because we're now getting into the nitty-gritty, but there's some macro parts of this debate, and that's why many of us think this is a great, actually, environmental response to get beneficial reuse and ensure that that occurs, which keeps our ability to place things in landfill at a limited amount. Mr. Martineau, as an experienced state regulator, do you think states are able to interpret the minimum program requirements in the bill to provide a permit program that is protective of human health and the environment?
Yes, I do.
What about this dam debate that we just had?
Well, I think dams are obviously in context well beyond coal ash disposal sites, but the structural integrity of dams, I'm not a dam expert in DAM, but those things are evaluated at the states. I mean, EPA, you heard earlier, they themselves went and looked at the 300 coal ash disposal sites and saw no immediate hazard. So I think
no immediate hazard, and the EPA went on record as saying that.
Yeah, I believe that's
that was the testimony. Yes, sir. Mr. Cobb, as an experienced state, I mean. Back to you, Mr. Martineau, the draft legislation sets forth detailed federal requirements that would establish a baseline for coal ash management across the country. Do you believe the requirements set forth in the legislation will ensure that states develop effective environmental protective permit programs for coal ash management?
Yes, I believe they do. I think the discussion draft, the Senate version from last year, covers the key elements of a program for groundwater protection, for closure requirements, for structural integrity, and other requirements. And the thing it adds, which the Subtitle D program does not have, is that permitting program. And then it provides that states have to certify the completion of those requirements to EPA, and they can evaluate those.
Thank you. And Mr. Cobb, I wanted to ask, as another experienced state regulator, do you think states are able to interpret the minimum program requirements in the bill to develop a permit program that is protective of human health and the environment?
Absolutely, Mr. Chairman. Quite frankly, that's what we do. We implement regulatory programs. We interpret.
You mean you can do it without the EPA coming in?
I have confidence that we can, yes.
You're not so diligent. I mean, so you're concerned about your state citizens, and that's the job that you have. Is that correct?
That's correct. Because in addition to having the job of protecting human health and the environment, we also have the added incentive that we and our families and our friends live in these communities. So we have a vested interest.
And if there is obviously abuse, which I think some people fear, don't you think that the public would be aghast and may want to take retribution on politicians and those who have been appointed as commissioners of environmental activities and throw them out of office? That's a political question. The answer is I would hope that response would be much better, and the public would be outraged. Ms. Bodine, when you were at the EPA, what was the prevailing view about coal ash regulation?
Yeah. As I talked about in my testimony, EPA didn't stop looking at coal ash with the 2000 regulatory determination because, in fact, the determination said that Subtitle D regulations were warranted. But as I pointed out in my written and in my oral statement, the agency just didn't have a risk assessment to support regulation. So the agency, we continued to work on the risk assessment, and we continued to gather information and did a report, an updated report on practices in the industry with Department of Energy, and also received a petition from environmental groups, received a voluntary plan from the industry, and we had a lot of information, and so we put out a notice of data availability in 2007 to make sure that the public and everyone knew what information the agency had. In preparing to release that, the staff briefed me on all the information that we had and that the agency had, and recommending that all be put into the public record, which is what we did. But in that briefing, the consensus of the staff was that certainly not Subtitle C regulation was warranted, And the question being raised was, given the information that being developed, whether even Subtitle D regulation was warranted.
Great, thank you. Now I'm going to get this correct, although he just, no. I'd like to recognize the new Vice Chairman sitting in, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman. I'm not Vice Chairman. In fact, this year, I am now because for the first time I can run the Democratic side. But last year I was ranking member on the subcommittee and learned much more about coal ash than I ever thought I would ever know. And we drafted a similar bill that, and we got bipartisan support out of the House for, that set up something similar to what this bill does. And I'm hoping to be able to support it again, but I have some questions of each of you. For our state regulators, Mr. Cobb and Mr. Martineau, given your position, what do you think would be the consequences of having a CCR program run through the EPA instead of the state-led program designed in the majority's discussion draft?
Well, one, I think, as Ms. Bodine is, EPA has grappled with this for 30 years and not come up with any solution, and they're still grappling with it. They don't know if it belongs in Subtitle D. If it's a Subtitle C regulation, that would be a disaster. We'll have chaos. We think the appropriate mechanism is, as the statute sets up, or that the states control, much like they do regulating landfills under Subtitle D. And the thing about the legislation is we can move forward with, once it's passed, just begin that implementation at the state level.
Mr. Cobb.
Yes, and I would agree with Mr. Martineau's assessment there that one of the key differences is with the legislation, it addresses the policy issues, the other issues that have balled this whole issue up for 30 years. It charges the states with going forward with implementing a program based on experienced programs. So we get it implemented faster, we get the protections in place faster. It was mentioned earlier that it's been almost 5 years since Kingston. We still don't have a program in place.
Well, I think, one of my concerns is that, and again, I realized we had testimony last Congress that, for example, Wisconsin recycles 97% of their coal ash. And in fact, now Senator Tammy Baldwin actually supported the bill in the subcommittee and the full committee and on the floor because of that. But we know we have some problems with coal ash. The issue of an old permit disposal in the Great Lakes, I think it needs to be dealt with. And Mr. Martineau, one of the issues that brought coal ash up originally was the issue of the wet storage. And Tennessee had that disaster. Has there been anything Tennessee's done under current Tennessee law that would deal with the problems of the weak dams and so we wouldn't see that? Now, we don't have that in Texas, but I know a lot of states still do have wet storage.
Well, yes, and I think first to put in context that the surface impoundment that was the main part of the issue at Kingston had been storing coal ash since the 1950s. So, there were no regulations, federal, state, local, any those environmental statutes across the board. So there was a landfill. And we have gone back, obviously, after Kingston, and that was before my term as commissioner, but the regulations were upgraded after that to basically design would require new landfills to meet basically the Class 2 industrial landfill sites, which require leachate collection, closure, a cap closure like a traditional landfill. So yes, we definitely have upgraded the requirements.
So Tennessee has done that since that disaster.
Yes.
Were you able to deal with any of the previously impoundments? Do you have any authority to deal with, a dam that may end up being weak and you may get folks downstream to be concerned about? Do you have the authority to be able to deal with that?
Yes, we did, and we ordered TVA to do assessments of all the other coal ash disposal sites at their various power plants, and with EPA, we looked at those, and certainly we'd have the authority to upgrade those. And as I said, now going forward, we for the landfill, they basically have to meet the Class 2 industrial landfill closure standards.
Ms. Evans, I know you may have an opinion on that. I would like to see it, coming from Texas, it seems like it's in our blood that the states ought to deal with it. But if we're not dealing with it, then it becomes a national issue. And in this case, EPA, I think, has the authority unless we set up a different structure, and that's what this legislation is about. What is your opinion?
Well, I think the states have the ability to deal with this, but they don't always have the will. I think Tennessee and Alabama are lessons to us. Of course, we had the disaster in Tennessee in 2008, but following that, the Tennessee legislature did not change their statutes to address the structural stability of dams. And so it remains that structural stability requirements are not specifically applied to coal ash dams. And this is after the biggest toxic waste spill in the nation. Also, I'd like to correct the record regarding the inspection of dams, specifically in Tennessee with TVA. When TVA inspected its dams, it found that half of them required repairs to ensure structural stability, and those repairs are underway or completed now. As far as the EPA inspections, there were urgent repairs that were noted in the inspection records. And in West Virginia, the West Virginia DEP inspected one dam where it was deemed unsatisfactory and needed urgent repair. So the longer I sit next to Mr. Spadaro and hear him talk about his experience and what's needed and knowing what's not out there regarding coal ash dams, it certainly scares me about what the states have not done. Lastly, in the case of Alabama, the legislature did address coal ash in 2011. However, they did not institute any regulations for coal ash ponds. Most of the waste in Alabama, I believe, is disposed in coal ash ponds, not landfills. Alabama legislature made their landfill regulations stronger. They did not change regulations applicable to dams. So what we've got here are states that are not ready to jump on this problem, solve the issue of disposal. And we may have a delay at EPA, but I am convinced that we're going to have a delay in state legislatures. And being from the very liberal state of Massachusetts, we can't even get our gaps closed in the state of Massachusetts, which we've been trying literally for 10 years with a bill in the legislature.
Yes, I have to talk to our colleague, Mr. Markey, about that.
That's right.
Thank you.
And I would just note Massachusetts is a member of ECOS. And I'd like to recognize Mr. Latta for 5 minutes.
Thank you very much, Mr. Chairman. And again, thanks for our panel for coming in today. We appreciate your testimony. And if I could start with Ms. Bodine, could I ask with this question first? In your experience, what constitutes a standard of protection?
I remember to turn that on. Thank you. This is a question that's been raised by CRS in the evaluation of the legislation, and the CRS analyst appears to be saying that the only standard of protection that Congress can put forth is something like protection of human health and the environment, and that is simply not accurate. Congress can establish performance standards that are, in fact, standards of protection. And I also have to note that while many of the earliest environmental statutes did say to EPA, go and protect human health and the environment, the Congress hasn't passed legislation that's that open-ended in a very long time. And that's for concerns on both sides of the issue. You've had people worried that the agency would go too far in that, and then people worried that giving the agency discretion to decide what is protective of human health and the environment, that they wouldn't go far enough. And so you've seen statutes that have prescriptive language, prescriptive standards. I would just point out the hazardous and solid waste amendments of 1984. Congress at that time decided they didn't like what the agency was doing to protect human health and the environment from hazardous wastes, and put in very prescriptive technical requirements into the statute. So yes, you can have technical criteria that are performance criteria, and that is a standard of protection, and that is in the draft legislation.
Okay, let me follow up with that. Do states also establish standard of protections for statutes, regulations, and programs that they implement?
So the answer to that is, of course, yes. I could defer to my state colleagues here, but I would just point out that they've been doing this for years. The states regulate far more than the federal government regulates. They have state solid waste management programs, beneficial use programs. They regulate more waste as hazardous than the federal government has. And of course, there's also regulation of coal ash. So in many areas and many programs, states are establishing and implementing their own protective standards.
Thank you. Mr. Martineau, let me ask this question. Mr. Stanislaus stated in his written testimony that timelines for the development and implementation of state programs are necessary. Would the states be open to a reasonable implementation schedule?
Yes, I think that certainly makes sense to provide time for the states to pass legislation, adopt rules, whatever they need at the state level to get that permit program up and running or anything like that would make sense. And then the statute already has certain timelines in there for when you do the groundwater monitoring requirements, or when the thing has to be upgraded by a certain date or closed by a certain date. So those kind of schedules all make sense.
Okay, thank you. Mr. Cobb, same question.
Yes, I believe that we would be very amenable to that kind of thing, particularly for the operational requirements, which can be implemented almost immediately or on an accelerated schedule and get the protections in place earlier. The more design-related considerations, in my opinion, would need to wait on the permits because that's changing the very fabric of how the units are built, and we need to make sure those standards are right before a facility begins constructing so that they construct it properly.
Let me ask a follow-up on that then. What would a time frame could the states live with if there were a deadline for issuance of permits? Please, Mr. Cobb.
Based on our evaluation of the universe that we have in Alabama, where we know we have at least 9 large facilities that will require permitting, looking at our current workloads and everything, we believe that 3 to 4 years after applications are submitted, we will be able to have all of our permits in place.
And Ms. Martineau, could I ask you the same question?
Yeah, and I certainly can't speak for all the states on that, but I would think 2 years to set up the permit program, adopt any state rules that are needed through the state rulemaking process or legislative approvals, and then some period of time, 2 to 4 years, to get the permits in place is probably makes sense. Would be about right.
Well, thank you. And Mr. Chairman, I yield back the balance of my time.
Gentleman yields back time. Chair now recognizes the gentleman from West Virginia, Mr. McKinley, for 5 minutes.
Thank you, Mr. Chairman. We'll have a whole host of questions here, but I think if we can focus in on Mr. Spadaro, please, if we could. I wonder if I didn't, maybe because of my hearing problem, maybe you misspoke or I misheard, because in your opening statement you made something about challenging the structural integrity. You thought that it was good, that it was only to meet good community standards. Do you remember saying that?
Can you hear me now?
Yes.
Is
that a yes or no? Did you say? I think you said good community standard.
I said good engineering standard.
Yeah, good engineering standard, and that's fairly typical in the industry. If you understand that. I mean, that people use that good engineering practices because it falls under. But let me go back to more. You're a licensed engineer?
No, I worked at the federal government for 30 years. But I ran the Dam Control Division,
okay,
state of West Virginia.
That's okay. So you're not a licensed engineer. A couple of things in your testimony that in your written testimony I found curious. You made a couple of statements in it. Just for the record, I'd like to make sure that they're correct, because you're testifying before Congress. You said that the Robinson Run mine was utilized as a disposal for coal ash. You know that's false.
No, that is not false. I'm sorry, sir. It was used for disposal from both the power plant and the coal preparation.
For slurry.
For slurry, and that's coal ash is delivered to the reservoir in the form of slurry.
I hope that apparently you'll be under oath when that comes.
Yes, I am under oath, and I understand that.
They're not delivered in the form of slurry. It was not used for coal ash. Secondly,
I'm sorry, but it was a coal ash.
Will the gentleman suspend? The time is the gentleman from West Virginia.
You also said that and by implying, you said that 25% of the dams were in poor condition. But the reality in conversation with the EPA, that the EPA said that just because they're classified as poor does not mean that they are unsafe, that they mean that they are just not meeting certain guidelines in terms of studies or paper evaluation. So let's just make sure that we understand the 25% that are rated as poor are not unsafe. They just have not met all the criteria.
I disagree with that statement.
Well, you can, and you're disagreeing with the EPA then.
Yes.
So as there also regards, you're aware that the federal government inspects dams. If they have any concern, they inspect them every 7 days, according to the federal regulations. You're aware of that?
They're required, the dams are required to be inspected by the mine operator every 7 days.
And in West Virginia, you have all our coal impoundments they fall under the Office of Surface Mining, MSHA, that you were involved with, and also the state DEPs also have inspection. It's done monthly, those inspections. So I do appreciate the fact that you were involved once as an engineer. I think you're out of touch.
No, sir. I've been regulating dams my whole career. And when I worked with the Office of Surface Mining, I wrote the federal regulations that are in this book. I wrote them in 1978. They're still in effect. And I've been enforcing those
You
regulations.
list yourself, sir, as on your resume as the Engineer of the Year in 1993.
I was by the National Society of Professional Engineers.
We talked to them today, and they said they have no record of that.
Well, I'm sorry, but I did receive it, and I have the certificate.
If you could, I'd like to see that. If you could
right.
submit that for the record, because in 1993, there is no such thing first as the Engineer of the Year.
It was
There
for
could
the
be
federal
a
government.
Federal engineer, but that wasn't awarded to you unless you were the engineer. Were you in the Air Force at the time?
No, I was
Because
working.
that's where it went. In 1993, the Federal Engineer of the Year was an engineer in the Air Force. So,
Well, listen, I was awarded that award as an employee of the Federal Department of the Interior in 1993 by the National Society of Professional Engineers, and there was an award ceremony, sir.
if you would send that certificate to, I'd like to see it and share that with the NSP because they have no record of you. You're not licensed in West Virginia. You're not licensed in Kentucky, but you're acting as though you're an engineer.
I have been qualified as an expert on dam safety in 6 federal courts in the past 30 years, and I'm qualified every day in federal and state courts.
I think
the
record shows that you're not a licensed engineer. And secondly, I agree with everything that's been said about the concern about the dam safety, and I think that people have moved. What you discovered in 72 or 75, that's yesterday.
I investigated.
So I think we're moving in a way that we go ahead, and I'm really glad to hear that there are other people. We are moving on it. That there have been improvements with those standards, and we can continue to do that. But some of the record that you're testifying to, that you're representing, is just factually incorrect.
That's not true. Everything I have said in my testimony is factually correct, and I have done dam safety investigations as recently as
Look forward to
this
your
past year.
testimony on the Robinson Run when they determined that it did not include fly ash. Apparently my time's run out, so I'll have to end at that.
Gentleman's time expired. The chair now recognizes gentleman from Mississippi, Mr. Harper, for 5 minutes.
Thank you, Mr. Chairman, and thank each of you for being here and sharing your views on this very important issue to us. And if I may, and is it Ms. Bodine or Bodine?
Bodine, thank you.
Bodine, thank you very much. Ms. Bodine, would you consider authority in the legislation for EPA to analyze at any time state permit programs and find programs deficient if they do not meet the minimum requirements of a federal backstop?
Yes, I would consider that to be backstop authority. The way the proposed legislation, the draft legislation works is that EPA has the authority to evaluate the state programs, and then if they are deficient, has the authority to then implement a federal permitting program in lieu of the state program, and that is a backstop.
Okay. The legislation sets out a detailed list of criteria that states must include in their permit programs. Is this approach completely unprecedented? Or when has it been done before?
Right. So, and I talked a little about this earlier. The fact that Congress can set up in federal law specific criteria is not unprecedented, and again has been done with very detailed statutory language in the hazardous waste context, where Congress was setting out minimum technology requirements and indeed specifying the number of liners, for example, that would be, and that's all in federal statute. So the fact that you would have federal criteria established in federal law is not unprecedented.
Okay, thank you. Mr. Cobb, how long have you been regulating solid and hazardous waste?
For 25 years.
Okay. Now, based on that experience of those 25 years, does the legislation contain all of the necessary technical elements needed to establish a protective permit program?
Yes, sir, I believe it does, because based on my experience both in hazardous waste and in solid waste, primarily in hazardous waste, going through the legislation, it appears to contain the things that we would need to be able to have a protective regulatory program.
Okay. Do you believe that the legislation allows states the latitude to go beyond the federal standards?
Absolutely. As I read the legislation, there is clearly the provision that allows states to go beyond the minimum national requirements.
Now, would the legislation result in states developing or revising requirements for CCR management that would go beyond current waste management requirements?
Well, I can only speak for Alabama, but certainly, because as has been pointed out, we have only recently been able to regulate CCRs. So what we will be putting in place as a result of this legislation or EPA rules or whatever comes out will certainly go far beyond what we have done in the past, and I would be very surprised, based on my experience in discussions with other states, if there would be any state that would not have to do some expansion of their programs beyond the current status.
And I think you've answered it, but just so that I'm sure, so would Alabama have to develop new requirements or make changes to existing requirements that may apply to coal ash?
Yes, sir. We have already incorporated coal ash into our landfill program, but we will have to add requirements, particularly for surface impoundments, for structural integrity, for any other units, and that is what we're ready to do. We're waiting on to see what the national requirement is to know how to put those in place so that we can do it, and we're ready to do it now.
I yield back.
Gentleman yields back the time. Chair now requests the gentleman from Florida, Mr. Bill Rockus, for 5 minutes.
Thank you, Mr. Chairman. I appreciate it. Mr. Cobb, a criticism of the legislation is that the flexibility in the bill would allow states to define what constitutes CCR, landfill, surface impoundment, or other land-based unit to define what specific CCR structures state program conditions would be applied to. Why is it a good approach?
Sir, I believe that this is a good approach because it allows states the flexibility to tailor their regulations to what exists in their state. It allows us to make sure that the regulations are better responsive to individual state conditions, to state geology, to state climate, in a way that often cannot be done with strictly rigid, uniform national requirements. It goes to the part of states being more stringent, of states having additional requirements. We need that ability to tailor the regs to make sure we can address what is in our state.
Thank you. Ms. Bodine suggests that these terms are well understood as the RCA, RA regulation context. Do you agree?
Yes, I would definitely agree with that. The terms such as landfill, surface impoundment, land disposal unit are used in all of the waste programs and regulations. And one of the things that you can take comfort in is we are regulators. As regulators, we like to have consistent definitions. We like to have consistency because it enables us to regulate better and more consistently across programs. So, yes, I believe that these terms are well understood and will be well represented.
Thank you very much. Ms. Boone, based on your experience, would the approach set out in the discussion draft be successful at creating state permit programs that protect human health and the environment?
I believe so, yes.
Do you want to elaborate a little bit on
it? I think that this may be the only way that we're going to get standards for coal ash across the country is through legislation, and that this is not only will it be successful, it may be the only avenue for success, and that goes back to my earlier discussion about the fact that EPA has not been able to create the record and have a risk assessment that justifies regulation, and so Congress can step in and say, as a matter of policy and as a matter of congressional prerogatives that they're going to set up a federal program. The legislation does that. We've heard from the state regulators saying, yes, it has all the elements. Yes, we can implement it. And so now it's just a matter of getting it done, of having Congress act.
Very good. Thank you very much. I yield back, Mr. Chairman.
Gentleman yields back his time. We want to thank this panel for coming and having their testimony. I'd like unanimous consent to submit 3 letters into the record. Well, actually 4 statements. 2 letters from professional engineering firms regarding the appropriate dam safety standards for coal ash impoundments. 1 letter from a beneficial user, the Portland Cement Association, and a submission for testimony from the representative of North Dakota, Mr. Congressman Kramer. Without objection, so ordered, and the hearing is now adjourned. Thank you all. Thanks for helping.
Glad to.